we have Rachel Suddarth and Laura Khatcheressian. Rachel is an assistant professor of legal writing at the University of Richmond School of Law. She received her law degree from William & Mary School of Law and her undergraduate degree from the University of Virginia. After law school, Rachel clerked for Justice Lacey on the Supreme Court of Virginia. After clerking for Justice Lacey, she was a professor at William & Mary School of Law. She has also been an associate at Hancock, Daniel, Johnson & Nagel here in Richmond, where she practiced regulatory healthcare law. And Rachel is an experienced writer whose work has appeared in numerous publications. She will be joined by her colleague, Laura Khatcheressian. Laura is an assistant professor of legal writing at the University of Richmond School of Law. Prior to joining the full-time faculty, she was an adjunct lecturer at the University of Richmond Robbins School of Business. Before entering academia, Laura practiced law at Reed Smith here in Richmond, where she specialized in immigration law. She has also practiced at McCandish Holton. Laura has been featured on numerous engagements on a variety of legal topics, has been the featured speaker on numerous engagements on a variety of topics. Please welcome Laura and Rachel.
Morning. Good morning. Welcome to our session on writing for clients. I've got handouts, so I'm going to wander around for a few minutes and hand things out. Don't feel like you have to read them yet, because I don't want you reading while I'm talking, then my feelings will get hurt and I'll think you're not listening to me. My name is Laura Khatcheressian. Joel, take those back too. And this is Rachel Suddarth. And as Joel mentioned, we are both teachers at the University of Richmond Law School. We teach legal writing and analysis. And just to give you a little bit of background, for the past, year and a half, we've been working to kind of tweak the legal writing program there to focus a little more on a process approach to give the students guiding principles that they can use to write any document, rather than just focusing on the types of documents and products that lawyers often deal with. Now, you guys have already been to law school, so we're not going to repeat everything that we do for our law students, because that would be boring. But before we shifted over into academia, both Rachel and I were practicing, and we remember how hectic and hard it is when you're juggling all the deadlines for the 16 things that are due tomorrow, and the client that you're writing to right now who really wanted this information yesterday, to remember all the beautiful legal writing techniques and tools that you have. So what we're going to share with you today is not necessarily information that you'll say, wow, I never thought of that before, but more information that will help you bring to the forefront some of the skills and intuition that you already have, so that you can integrate that into your daily writing practice. And when you do write and communicate with clients, you'll be able to do so more easily, more efficiently, and be a more effective communicator with your clients, which is a good thing, right? Does that sound okay? Okay, so we've got several different things that we're going to talk about, because we only have an hour. If only we had more time, right? Because we only have an hour, we're going to focus our attention on just a few things. We're going to start off with reminding ourselves about some basic communication theory principles, focusing on our audience and purpose, and then talk through some exercises and examples, tailoring to client letters, thinking about writing strong introductions, thinking about tailoring content to your client, and thinking about writing strong conclusions. And then hopefully we'll have some time to ask and answer questions at the end.
Can you all hear us in the back if we don't use it?
Can you speak up a little?
Speak up a little. We can stand at the podium.
I can stand over here. It's just
natural wanderers.
If you just speak up a little bit, I think we'll be up.
All right.
I can try to project more, or you could come up here. There's lots of chairs here in the front. You'd rather me speak up than you have to move?
Just like the one else.
I can just walk up here and yell at you. Or those wave or something if you can't hear me, because that'd be sad.
Yes.
My sister is also a professor, and nothing. She told me once that on an evaluation for one of her adjuncts, she manages adjuncts. How's this?
Open.
Is that good? Okay. She told me once that somebody wrote on an evaluation form for one of the adjunct faculty, at the end of the semester, the student wrote, "I couldn't hear him because he spoke so softly." Wouldn't you think you would bring that up like at the beginning of this semester? Okay. I digress. Okay, so let's talk a little bit just about basic communication theory. So writing is communication, right? It's one of the many ways in which we communicate with our clients. We can still hear? Yes? Okay. And as with any communication, it's good to step back and think about what it is that we're doing. Well, when we communicate with people, we have a sender, someone who has a message, some kind of content that they want to get out there, and a recipient, somebody who's ready to absorb that information and maybe do something with it. All right. So a lot of times, as legal writers, we focus intensely on the content, on the what we want to say, or what we have to say, what we need to get out. What we want to do today, in part, is shift our focus a little bit to thinking more about the recipient and what the recipient needs or wants to hear in order to really absorb the information and act upon it in the way that we want them to act upon it. So, one of our guiding principles for today is to think about who our audience is, how they will interpret the information, and make that principle explicit in everything that we do. Thinking about who they are, and also thinking about not just who we are and what we feel like we have to get out there, the analysis that we've worked so hard as lawyers to develop, but what we want them to do, what we want to achieve with this individual communication. Not necessarily with the client as a whole, but in this communication, what we want them to do, how we want them to react, how they should take this information and the steps that they should take, anticipating their reaction. Rachel's going to talk a little bit about some of the questions that we ask as we think about audience and purpose analysis.
Okay, so in a lot of communications, as you know, there may be multiple audiences. There's your primary audience. And your primary audience is literally the person who you write the letter to, right? It's addressed to. But a lot of times there are also a lot of other people who might read your writing, okay? So first we're going to think about, what do I need to know about the person I'm actually addressing that letter to? Again, as Laura said, so often we focus on what we want to tell them, and we don't stop to think about the attributes of the person that we're actually writing to. So when you sit down to write a letter, the first thing you should really do is think about who is going to be reading this. Okay, so things like, what is their level of education? What is their exposure to legal analysis? What is their sophistication? And in all of these examples, I think it's helpful to think about writing two letters. One to in-house counsel at a big Fortune 500 company. One to a person pursuing a divorce who has a high school education. You would write very different letters, as you know in practice, right, to those people. But sometimes we forget and we get busy and we sit down and we're so focused on just getting our analysis out there. Yes, you can get a divorce. Here's the statutory provision in Virginia where you can get a divorce. Does our person with a 12th grade education really want to know the statutory code provision so they can go on Westlaw and look it up? Probably not, okay? So we need to be mindful of who we're writing to. We want to know what their likely reaction is to the document, right? It's important to know if you're going to make them angry before you hit send. That's a good thing to know, right? And if you're going to make them angry, maybe you don't make them angry in the first line so they stop reading. Maybe you make them angry on page 2, right? Important things to think about. What information do they need to know? Which is often different from what information I want to tell them, right? What does your client want to know? The answer. What do you need them to understand? The background legal framework, all the ramifications of the answer, all the qualifications that went into your legal analysis. Do they care about any of those things? No, but we care about malpractice. So we put them in our letter, right? Okay. Your secondary audience. I used to work for a partner who was notorious. I would write him a nice, beautiful memo, and it would have all this analysis, and I would say, gosh, the client seems to have made some mistakes here, and you know what he would do? You guys have all done this, or worked for someone who did it, right? He'd flip it to the client without ever reading it. Well, I learned that lesson really quickly, right? Okay, if there is someone who you know is going to get this letter, you need to be thinking about them too. So let's look at a less sinister example. You work for, you're writing a letter to the chief legal officer, the in-house counsel for a Fortune 500 company. If you know that that Fortune 500 company's in-house counsel automatically flips every letter over to the CEO, what do you need to take into account? Well, your CEO is probably a really sophisticated person. But have they gone to law school? Have you explained all the underlying information that a CEO would need in order to understand the issue versus what that primary audience in-house counsel needs, right? So it's important to think for a minute, who else might read this letter? If I know someone else is going to read this letter, what information do I need to put in order to target that secondary audience who I know is going to pick it up, so that they don't then have to call me or go back to in-house counsel and say, I can't understand this letter, right? So we asked, who are there any anticipated audiences? Same question. Who are they? What are they like? What is their likely reaction, right? In-house counsel might be like, oh yeah, we really messed up. CEO want to hear you messed up? Might want to temper your language a little bit, right? What information do they need to understand? Again, if they have different attributes than the primary audience, you want to take that into account. Your job when you are writing, writing a letter to an entity, and you know that letter is going to be shared amongst people, is to try and strike that balance between the person who you are writing to and the other people you know will read that document, okay? And it's worth taking a minute to think about who those other people might be. All right, so moving right along, the second thing we try to think about is purpose, right? Why are you writing to these people, okay? What instigated the preparation? Was it assigned? Did they ask you a question? What do they want to know? Again, what they want to know is often different from what we want to tell them, okay? But if we structure our letter so that it only covers what we want to tell them, do you think they're going to be happy reading your letter? No, because it doesn't tell them what they are interested in, okay? What's the main action or outcome? Can they tell from reading the letter what they should do next? Do you give them action items? Or do you simply say, I'm sorry, it doesn't look like this cause of action is going to work out. Okay, well, are there any other causes of action that I could pursue? Am I dead in the water? What's going on, right? How do you want them to use the document? Is it a checklist for things you need them to do? Or is it something they can file away? And what do you want them to do after reading it? Okay, so we have our first example here. It's on the front cover of your packet. Take a second and read it.
Just take a minute and look over this one. It's the one that says the billable hour rate change email.
Are there extra
packets? There should be enough for everyone.
Ah, here they are. They're in the front.
There should be plenty. Okay. All right. Has everybody had a chance to skim over that, or am I rushing you? So we have a chance? Yes. Good. Thank you for the feedback. Okay. So what are we looking at here? This is an example of someone trying to convey some content, right? Are they doing a good job of conveying the content? What do you guys think? Thumbs up or thumbs down? All right. we've got some mixed reviews, but it's not looking overwhelmingly enthusiastic. This associate has done a decent job of conveying the information that he or she was asked to convey, right? But has probably not given a great deal of thought to the impact that it's going to have on the person to whom she's writing. What is the client's likely reaction when she gets this email? It's forwarded immediately. What do we think, people who are like here, Sandra? Yeah, maybe negative, right? Could we rework it to make it more positive when the client gets it? Do we have information here that we could utilize? Yeah, because what the author has done here is focused on the primary purpose. I need to get this information out, only. And forgotten about the secondary purpose of really not just this client communication, but all our communications with clients, which is what? What do we want to do when we communicate with our clients? What is our secondary message to them?
You're valuable.
To help the relationship, right? To say, client, we love you. It's not just about money to us. Well, maybe we did. We want you to keep coming back, right? So this is just a fun little example of someone who is trying to convey the content, forgetting about the audience and the purpose. The main takeaway here is, again, it's nothing that you're going to say, wow, I never thought about who I was writing to when I wrote a letter, but just to bring that up explicitly so that when you sit down to write, you don't allow yourself to get sidetracked into all the information about content and forget about what I'm trying to achieve, not just primarily, but secondarily with each communication and how this person is going to react. So let's shift our focus a little bit away from emails, as fun as they are, and think about writing a client letter. Now we've got some factual scenarios for you here, and I will warn you in advance that we made these up. So these are not real people, and some of the legal stuff may seem a little unusual. Don't get sidetracked by that. We just want to give you an example, okay? So here's our factual background for the next example that we're going to share. We've got our client, Lisa Corona Jackson. She is heir to the Corona beer fortune, which must be fun, right? She lives in Raleigh. She just got married a year ago to a man named Arthur Jackson. And the first 6 months, everything was great, but recently everything has fallen apart. So Arthur has moved out of her house, out of her bedroom, I should say, within the large house that they have, and into a guest apartment that is on the property. He and his friends make fun of her as she walks to and from her car and say nasty things about her weight gain and things like that. And he does not spend time with her and rarely talks to her. She's tried to talk to him, but he doesn't seem all that interested in speaking to her about it. So, in 4 months, our client is turning 30. It's a big deal. On her 30th birthday, she's going to get a bunch of Corona stock. Yay! But her trusted, she's married on her 30th birthday. Her husband gets joint stock ownership. Okay. Yeah. Who drafted that? I don't know, but it works for us because we want her to get a divorce fast. So, she'd like to divorce Arthur soon before she turns 30 so that she can avoid him getting all the access to the stock. And she's hired us to advise her, is there any way to divorce him? And for the purposes of our exercise here, just assume that a divorce from bed and board is going to work as well as a full-out regular divorce would in order to satisfy that clause of the trust agreement. That will count as them not being divorced. So that's our factual background. Let's take a moment and look at the next 2 pieces of paper in your handout, example A and example B. And then we're just going to talk a little bit about them, about some of the differences and which one we like better. All right, have you guys had a chance to look at both of them? Yes? All right, let's take a vote. Raise your hand if we want to write example A. Raise your hand if you want to write example B. Raise your hand if you want to write something even better than example B. Ooh, yay. Before we start talking about the examples specifically, let me ask you, is there anything that we need to know before we know what we're doing here, before we start writing? Any questions that you guys have? You have a question?
Well, just things we might want to know. Does Lisa like her husband?
This is a good thing to know. Does Lisa like her husband? Yeah, that would be great to know. What would we do with that information?
Well, if she ever wants to get back together, do we want to create something that protects her assets but doesn't ruin her chances?
We might want to be thinking ahead about different ways to advise her. We also might want to think about our language. If she really still loves her husband, but still wants to protect her assets, we may want to refer to him differently in the letter than if she's come in and told us that he is the lowest of low, scum that's walking on the earth, and wants nothing to do with him. Now, there's a couple of things that are happening in our example B that are good even without knowing any of that, and then help us do a better job than example A. Example A starts off with the North Carolina statute, right? And gives the client all the language from the North Carolina statute. Do we know if Lisa's a lawyer? No. If I didn't say so, we might wonder, but if she isn't, she may not want the block quote from the statute. Now, we may love the block quote from the statute because it's really fascinating to us, and we spend a lot of time thinking about it and looking at every single one of them and saying, well, maybe it could be maliciously turned her out of doors, or maybe he endangered her life. I don't know. Maybe it was indignities. She doesn't care. She just wants to know immediately where we're going with it. Let's flip ahead to there. When we look at the next example, instead of starting with a block quote from the law, we start off by saying, look, we know where you're coming from. We understand what the issue is, and we're going to try to help you. This, like many of the things that we talk about when we talk about legal writing, seems really obvious, but is really, really easy to forget. The first thing that the reader asks him or herself when he picks up your letter is, do you understand where I'm coming from? Are you going to speak to me in terms that I understand? Or are you going to waste my time by telling me stuff that I don't understand, don't have anything to do with, and don't want to know? So we want to be cognizant of that and explain, why are we writing? What are we going to do to help you achieve what you want to achieve? We also may need to give some context. If there are several different options available in the law, we may want to let the reader know that we've looked at all of those and selected one that is best suited to help her. Give her some preliminary information, summarize the reasoning, and this is all before we ever get into any kind of detailed explanation. Now, the detailed explanation, the analysis, is going to be really important. But before we get into that, we need to contain that detail within a context and an overview that tells her why we're writing. As lawyers, when we're busy, we have an inclination to slip back into using the terms and phrases that we are familiar with from working in the law. But nobody else thinks like lawyers do, which may make us wonder whether we're thinking the right way and everybody else is wrong, but that's a whole other question. They've done some interesting research studies about what makes people think that the writers are smart. Now, our intuition may tell us that we will seem smart if we use fancy language and we sound like lawyers and we quote from statutes and we tell people about cases. Actually, what makes people think that you are smart when you're writing to them is if they feel smart reading it. They don't care whether we sound smart. They care whether they feel smart getting the information. So if we use terms that we're like, wow, I know a really big word, I'm so cool, turns them off. We don't want to do that. Instead, we want to give them the impression that they are totally able to take charge of their own legal matter, with our help, but they are able to get it. They are smart enough, competent, and capable enough to do what they need to do. So, we also want to include limitations. If we need information, it may be good to tell them that immediately, rather than waiting until halfway through the letter where I say, okay, so I said that I thought we could do this, but really it's dependent on whether you can get me X, Y, Z pieces of information. I hope you can, because all the other information that I've premised this on has been on that assumption. All right, so that's our strong introductions. Once we get past the introductions and we've written a beautiful overview that makes our reader feel like they are smart, reminds them that we are on their side, now we're ready to get to the heart of the letter and the content. And that, too, we want to tailor to our audience, keeping in mind our purpose. I'm just going to talk about that.
Great. Okay, so as I mentioned, I think it's helpful to think of our two examples here, right? Our in-house counsel attorney and our individual seeking a divorce with a high school education. So let's think through some of these considerations. First, are we going to give them a summary of our findings or our full legal analysis? Well, what do we know about lawyers, present company included, right? You are distrustful. You want someone to prove it to you. You're not just going to take their word for it, right? You're busy. You don't have time to wade through pages and pages of stuff. You want someone to give you the answer up front, and then back it up later when you have time to go back and read through their analysis, right? You have a million other things going on. They need to hold your focus. What do we know about lay clients? Generally speaking, they trust you. They have hired you because they trust you, and they want you to give them an answer. Generally speaking, they don't care about the statutory provisions because they don't have access to Westlaw anyway, right? So if we are going to write to these two different people, we might want to give our lay client a summary of our findings and explain generally what the law says about whether he can obtain a divorce at that time. Whereas with our in-house counsel, who clerked, by the way, on the 7th Circuit and spent 5 years here at Hunt & Williams as an associate, he cares a whole lot about your legal analysis. And he's going to go behind you and make sure that every single thing you put in that letter is accurate because, well, that's what they're paying you for, right? So we need to be really careful and include a full legal analysis for that client. And along those same lines, do we put in an extensive discussion of all of our sources of law or a summary of the law? Well, as you can imagine, our in-house counsel is going to want to know what those sources are. What have you premised your decision on? Do they think that you missed things, right? Is our lay client going to do legal research? No. They need to know that you looked at 6 cases and here's a summary of each of them? No. That doesn't matter to them. They just want to know the answer. Along those same lines, even if you describe the law for your lay client, are you going to include citations? Is that important to them? No. But it might be really important to your skeptical in-house counsel, who probably wants to know exactly where you found something and doesn't want to have to recreate your research trail. We talk to the students a lot about citation, and I like to tell them, I know you hate the Blue Book. We all hate the Blue Book. The Blue Book is not designed, believe it or not, to make your life miserable, although it may do that. The Blue Book instead is designed to prove to your reader where you got things, and to give them a trail so that they can go behind you and find the stuff you looked at, right? And so your in-house counsel is actually really going to care about that. So you want to put in your citations. Do you put in extensive background information or just do a targeted discussion of a very narrow legal issue? When you are writing to someone who is not well-versed even in the area of law, even if you're an attorney that you're writing to, if they don't know a whole lot about the area of law that you are writing on, you may well need to give them a background education on that area of the law before you jump into the narrow legal issue. So often we jump in and we say, oh, the narrow legal issue is whether you violated Code Section 1234. Well, why do we care about that? Well, because you're under investigation for all these other things, and 1234 is the linchpin in it, right? But they won't understand how we got there unless we give them a broad overview of the law, okay? This is an especially important consideration when you start thinking about primary and secondary audiences. Remember our in-house counsel CEO example. When you write to in-house counsel, you might be able to jump right to the legal question that they ask you to investigate. But if you know this is in-house counsel who tends to share that letter with the CEO, who has no legal training, or who has limited exposure to this narrow issue, in other words, they're not the one who asked you specifically to look into this because it's front and center on their mind and they're busy running a company, you might want to put a little bit more background information into that letter to educate your CEO, even though it's not necessary for your primary audience, who's your in-house counsel. So the other thing that I want you to think a lot about is helping your reader read your letters. So often, again, it's about getting the information down on the page, doing it as quickly as possible, right? Because we have 90 other things that we're trying to do. And we know what we're trying to say, so we put it down on the page and we dump all of that information in. Unfortunately for our reader, getting a 10-page letter with very little explicit organization is very difficult to wade through, okay? So I'm going to remind you of some techniques that I know you've used in the past. and encourage you to use them even more in the future, because in some of these, you can't overdo it. So generally, you want to begin your letter with the most important information that they need to know. Laura already talked about this, right? You start with your strong introduction, and you tell them, here's the most important thing you need to know. Don't give up on me. I know this is a long letter, but I'm going to summarize what you need to know in the first 2 sentences. You can read the rest of the letter at your convenience. You want to describe the preliminary information that they need to know before jumping into a longer analysis. When you're writing to clients, what's one example of preliminary information you often need to put up front? The factual basis that you based your legal analysis on, right? A lot of times, you need for them to check your factual analysis. And you say, here are the facts that I used to craft this analysis. If any of these are inaccurate, please let me know immediately, because it could totally alter my analysis. That's the type of preliminary information you want to put at the front of the letter, because you think they're more likely to read it on page 1 or page 9. Page 1, right? Your background legal framework, again, if you need for them to understand where this narrow issue is positioned in a broader issue, you need to explain the broader issue up front. The scope of your analysis. If there is a 3-part test, and in-house counsel said to you, I got the other 2, I just want you to look at this one narrow issue. Guess what's going to happen when you send back the letter on the one narrow issue? They're going to say, gosh, why didn't you look at all 3? I thought you were handling this for me. It is often helpful to us, as a little CYA, to say, you asked me to look into this one narrow issue when we spoke because you were going to handle the other 2. Here's your one narrow issue letter, yay, I did what you asked. Rather than sending them the narrow issue letter and having them say, wow, they really didn't answer my question. Okay, so if you are retained to write or do an analysis on of a limited scope, remind the person who retained you of that scope. So here are some of those organizational techniques that I'm going to encourage you to use. We talk a lot about chunking. I make this joke with my students about trying to get them to remember the concept of chunking, and I talk about the truffle shuffle and goonies, and every year less and less we get that, and it's so painful to me, but I'm just going to keep pushing through because I can't let it go. So anyway, now you have a vision like chunk, right? Truffle shuffle. If you haven't seen goonies, go watch it. You guys are killing me. Okay, so chunking information. If you remember nothing else, remember that right from today. Chunking information. Break down large amounts of information into digestible chunks. Your client cannot digest 4 pages, whether they're legally trained or not, of straight text, okay? If you have 4 elements, break down your analysis into the 4 elements. If you have 10 pages, figure out a way to put in digestible chunks of information. That can be in the form of paragraphs. It can be in the form of long sentences. If any of you are writing 5-line sentences, stop it now. Stop the insanity. They don't want to read it. I don't want to read it. I tell everyone else, please stop. You're killing me, right? Break down those long sentences into more digestible chunks. Break down your long paragraphs into shorter paragraphs. Break down extensive legal analysis, which is really, really important and 3 pages long, into little subsections. When you present those chunks, decide on an order that works for you and works for your client. If you have a 4-part test in the statute that you need to address with your client, but the only part that matters is part 4, do you go through sections 1 through 3 first? Well, you've probably lost them then by the time they get to number 4, right? Just because our legislature wrote it with the important part being part 4 doesn't mean we have to buy into that. Similarly, you guys know this from writing briefs, right? When you write briefs and you're writing a reply brief, do you take the organizational structure that your opponent set forth in their initial brief? No, you say, that's nice that they have 3 assignments of error. I think that the only one that matters is number 3, so I'm going to talk about that first. It's the same thing in writing client letters. We have a 4-part statute, but I'm not going to drag you through 3 parts that don't matter before we get to the part that really matters. I'm going to move that up to the front. You want to use explicit organizational tools. It's not some sort of derelict term here. What do I mean by explicit organizational tools? Well, I mean things like roadmaps. You guys remember road mapping? Tell your reader what you're going to tell them, and then follow that order throughout your document. If you say, this is a 3-step analysis, step 1, step 2, step 3, then please organize your letter, step 1, step 2, step 3, right? Headings and subheadings. You can't have too many headings and subheadings, right? Headings tell your reader, especially busy readers, where they are in the document. Make your headings substantive, right? So instead of just saying discussion, Part A, introduction. Make your headings and subheadings do some work for you. Have them deliver your conclusion up front so that if all your reader has time to do when they're walking into a meeting is read your headings and subheadings, they know a quick outline of your conclusion and your analysis. Okay? Topic sentences and transitional phrases. Again, it's especially important if you have a 4-page analysis. When you break it down into those chunks, you want to make sure that at every paragraph, your reader remembers what that section is about. They know what's coming in that paragraph. Again, I'm not suggesting that you guys don't know what topic sentences are, but I am suggesting when you sit down to crank out those 5 letters that you have to do today, that you're going to forget some of these techniques which are so easy to just remind ourselves of, implement, and craft these letters that your reader is going to actually want to read. Bulleted, bullets, numbered lists, white space. Okay? I think a lot of times as lawyers, we get so focused on formal communications that we forget that a lot of times for a client, putting something into a bulleted or numbered list is actually really helpful for them. If you say there are 3 things I need you to focus, our tendency from probably brief writing, from memo writing in law school, from writing letters to partners, right, is to put that information into a paragraph. First, this happened. Second, this happened. A lot of times for a client, especially those who are less sophisticated, if you break that out into 3 bullet points or a numbered list, it's much easier for them to read and follow and say, oh, it's just 3 little points of information, rather, wow, that's a 1.5-page long paragraph that I have to sort through. All right, so one last example for us to look at today.
Okay, before we start looking at our examples of conclusions, talking a little bit about them, I want to throw a tiny bit more research at you, and it's from an area that I personally really like. It's about cognitive science and how people's minds work to access information. Because as we go through all this, it all sounds intuitive, but I thought you might like to know it's backed up by science in terms of how people's minds work. The process of learning or absorbing information requires us to not only take information in, but then also pull information from our existing knowledge and integrate the two together in order for us to really understand it. A lot of the techniques that we've been talking about and that you have learned about in other writing seminars or writing or just by doing it because it intuitively makes sense, are drawn from that understanding. So when Rachel talks about chunking things into small pieces and linking them to existing knowledge makes sense to us because that's how we're able to retain information. If I give you a list of letters and ask you to remember them, so let's say I tell you, all right, X, F, B, I, P, H, D, C, N, N. You guys got all that? Everybody recite it back? Volunteers? No? X? Okay. Our working memories are usually able to hold about 4 to 7 pieces of information at a time before we lose it. If we chunk that information, we're able to hold on to 4 to 7 chunks at a time. So how about instead of that list, I tell you this one. X, FBI, PhD, CNN. You tell me that one? It's the same letters. All right, so chunking actually draws from the way that our minds work. Same thing with explicit organization. If I start talking to you and I say, well, the really important thing is that you need to divide lights and darks, and then you may need to organize into several different piles, or maybe one is enough if you don't have too much to deal with. You guys clear on what I'm talking about here? You're clear on what I'm talking about. All right. Working mother? How about if I tell you this is how we should organize when we do laundry? Then you're able to access existing knowledge. So that's why we're giving background first. That's why we're linking it. That's why we're chunking. All right, just wanted to take 5 minutes to throw out personal cognitive science stuff because I love it. Let's now take 5 minutes and look at our alternative conclusions for Lisa Corona Jackson. See what we think it goes. a chance to read both of them? Skim through both of them? Yes? Okay. Do you guys want to vote, or are we clear on which one we like better? Why? What's wrong with the first one? This is more fun if you guys participate too. What's so terrible about the first one? What do you think?
It gives basic information, but doesn't tell you what to do with it.
Right. Okay, so I've said, here's all this information, you figure it out. Are most of your clients able to figure out what to do if you don't guide them?
That's definitely not what they're paying you for.
That's not what they're paying us for, and we like to get paid. So it's good if we give them some guidance. So we could use a little more explicit guidance. Anything else that is problematic about it?
It refers back to itself. It says stuff like, however your case is more like the Richardson case, and the client has to go back and go, what's the Richardson case about again? And that just makes them lose the train of thought and get confused.
Right. If I refer back to something that maybe I've explained in detail early on, but without reminding my audience what the significance of that is, it's now out of context for them. They don't have anything to connect it to in terms of the knowledge that they already have. So again, with cognitive science, people learn and understand by connecting new bits of information to information that they already have in their heads. How many of you have clients who come in and say, well, I want you to advise me about this, but I already know X, Y, Z because my friend did this and she said blah, blah, blah. Yes? Now, if we just tell them, look, forget about everything that your friend told you because that's all nonsense, only rely on me. First of all, it hurts our credibility because they like their friends. And secondly, it doesn't allow us to really maximize the impact of what we're telling them because we're missing the opportunity to link it to stuff that's already in their head, that they already understand. And that's exactly the same point that the gentleman in the back is making when he says, you reference the Richardson case, but I have to figure out what it was because that's not in my head. Now, another reason that the Richardson case might not be in Lisa's head is that Lisa probably doesn't understand, as we do, the significance of why she should care about the Richardsons, who she doesn't know, and she doesn't want to know them, and why she would want to know why her case is like theirs is beyond her. What she wants to know is, can she get a divorce from Arthur? Now, if we're writing to our in-house counsel and we say, well, this is really more similar to the facts of the Richardson case, he's right there with us, right? She's not. Any other problems that we're looking at with example A that we could maybe improve that? There's lots in there to pick apart. Yeah, that.
It doesn't tell her what to do next.
It doesn't tell her what to do next. Yes, getting back to our explicit guidance point, not only does it not give her general guidance, but she gets it and she's like, okay, should I call you? Should I gather some more information? Do I just keep doing what I'm doing? What? I don't know what to do. I'm not a lawyer. I don't understand what information there is. I can't emphasize this point often or strongly enough, and this is something that I often fail to do well in practice. I would forget. I'd get all the way to the end, and I'd be like, okay, I've gotten everything in there. I'm done, I'm done, I'm done, I'm done. And I'd slip something at the end like, okay, call me if you've got any questions. And I'm missing the possibility of really getting more time than I could. I mean, there's nothing wrong with ending a letter with, please call me with questions. That's great. But if the client has told me I am in an extremely time-sensitive issue, and I send them a letter and I say, okay, call me soon, to me, soon means you better call me really soon because I've got 16 other matters on my desk. To the client, it may mean, okay, I'm going to call you right before it's due and remind you that I exist and tell you, yes, I do want to go forward, and the deadline's tomorrow. So if you just say, please call me with questions, you miss the chance to give more explicit guidance. Let's go forward. So when you get to the end of your document, not only do you want to take this opportunity to remind the audience of your conclusion, we all know that. We studied Iraq and Iraq and all that stuff in law school. We know that we're supposed to end with a conclusion. But we could also remind them of the reasons and tell them what it means for them. In our mind, that's crystal clear. And we often forget to make it crystal for them. tell them explicitly what they need to do right now. Do they need to call you? Great. Do they need to call you within the next day? Within the next month? Do they need to call you in 6 months? When do they need to do it? Is there information that they need to have in their hot little hands before they make the call to you? If I just say, call me, and you call me, and I say, great, I need those answers to those questions that I asked you, and you say, well, you didn't tell me to call you when I had those answers. I don't have any of that information. I'm just calling you. Here I am. Tell them explicitly what you need. I need you to get X, Y, and Z, and I need you to call me on Wednesday. If you can't reach me, I need you to set up an appointment with my assistant so that we can go over these things. Or, I need you to talk to X person and then report back to me. You need to give them explicit guidance. Also, you want to tell them what happens if things don't go this way. If you don't call me, and you want to phrase it carefully because you don't want it to sound like a threat, but you may need to let them know, if you don't call me soon, I may not be able to help you. If you call me the day before you want to file this, I don't know that I can do that. You know, we want to get that message out as well, but in a way that they will understand that we're trying to help them, that we're on their side, and that these are the steps that they need to take in order to get to where they are. Now, we also want to think about alternatives. Lots of times we get questions, and the answer is not something that our client wants to hear, right? Anybody else had this experience? Or anybody have clients who you only tell them good news, they come in with a problem, and you say, yes, I can do that? No? Do we ever have times when somebody comes in and says, I would really like to do X, and we say, you can't do that under the law as it currently exists. That's not okay. If we are in that position, as tempting as it is to just say, you asked me a question, the answer is no. Here are the reasons. We also want to do better than that. We want to explore alternatives. You can't do X, but I understand that what you're really trying to get at is this goal. This is what your underlying desire is. All right, so if Lisa came in and she said, I want a full-out divorce, and we said, you can't get that, you haven't been separated for long enough. That would be a short conversation, and then she would go away, and we would lose the opportunity to have a paying client for several more months. That would be bad, and she would be angry, or at least disappointed. But if we say, okay, you can't do the regular divorce that your friend down the street did after she was separated from her husband for 6 months, but you might be able to do this alternative divorce from bed and board, and under the provisions of your trust agreement, that would serve your goal just as effectively as the original one that you came in and you wanted me to do. Now, obviously, in order for us to offer those alternatives, we need to make sure that when we have our initial conversation with the client, we actually understand what their real goal is and not just the question that they're asking us. That's kind of a whole nother discussion about listening and communication skills. All right, let's take a moment to wrap up and see if we have some time for questions.
So again, our goal today was not to make you relive or let you relive, depending on how fond your memories are of your 1L year, your 1L legal writing class. We know that you all do this every day. But our goal was to give you some things to think about, some questions to ask yourself, so you can say, gosh, am I setting myself up so that the person receiving this letter is going to want to read it? Or am I setting myself up so that they're going to be in agonizing pain while they try and make their way through my 10-page letter? I know which one I prefer, right? I wish my 1Ls would all help me with that, but we're getting there, right? Week 4 of this semester. Okay, so here are some things that I want you to think about. Who are you writing to? What is their question? What is their broader legal purpose? If it's different from their question, because a lot of times it is. How can you address that audience and purpose in your content choices? How detailed should it be? How much legal information should you put? How can you help them read through your 10-page letter by using some organizational techniques? How can you make their life easier when they're paying you to give them information? Right? With your presentation, what wording should you use? right? We didn't go into this a whole lot, but if you have to deliver bad information, think a little bit about how you can do that in a way that's not just, sorry, the answer to your question is no, right? We want those clients to come back to us. We want to show them that we're really sorry the answer is no, but guess what? You can do this other thing and it's going to get you to the exact same place, so don't worry about it. Now, it's the nice day when you can deliver that information rather than sorry the answer is no, or sorry you're going to jail. Those letters happen too, but you know, we maybe soften the blow a little bit with our kids. You remember that your goal here is to strike a balance. You're busy and you've been asked to do a specific job, and your goal is very clear. Assess this legal question, give answer to client, right? But what they may be looking for out of that letter is very different. I want to know my lawyer cares. I want to know my lawyer heard me when I came in and cried for 3 hours about how my husband is really mean to me and calls me fat all the time, right? I want to know that my lawyer cares about me because that's the lawyer I'm going to hire when I have all these shares of stock and I got some money burning around and I'm trying to set up a foundation, right? So it's worth your time to set up that rapport with the client, okay? And also think about, gosh, who else might read this? Is this just going to go to Lisa, or are they going to reconcile and she's going to flip it to Arthur? And he's going to be really mad and co-owner in that stock. Okay, well maybe I'm going to pick my wording a little more carefully. Remember, you can write letters that your clients want to read, even when they're long letters, right? We all think of our client opening the letter like, oh great, letter from the lawyer, here we go. But if you set up from the beginning of the letter that you are answering their question and you are helping them, and you make it easy for them to get through that letter, you can deliver the exact same information, but they'll actually want to read the letter because they want to know the answer, right? And if you give them very clear steps at the end of that letter for what to do next, then you're setting up a situation where you're not going to be frustrated because they don't call you or you don't know if they didn't get the letter, or you don't know if maybe they're just ignoring you or they're angry. Instead, if you say, please call me with X, Y, and Z in the next 24 hours, and they don't call, you have an immediate feedback. Okay? All right, so I think we have a few minutes for questions. And we're happy to answer them or let you go to your break. All right, well, thanks so much for having us, and we hope this was helpful.